Today is a day of a tale of tales that the world know very well. But to them that the story is told about forever remains a tale. But on this joyous day of days, what was lost have now been found. Them who helped to uncover the truth will live in the world renowned. Return of the King, return of the King, make way, make way, make way. Return of the King, return of the King, forever where he may reign. Time waits for no one, 'cause everyone's subject to time. From tales of God to tales of men, therein your answer will lie. Return to the King, return to the King, make way, make way, make way. Return to the King, return to the King, forever where he may reign. Testing, testing. Greetings, 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 greetings. It is I, your King, Clifford Jefferson, descendant of Godfrey the fifth kind of Van Juice, son of folk bull of Jerusalem, reincarnation of Jesus Christ, which we know as King Edgar the Peaceful. I have beside me my queen, Sister Godwinson, from the House of Godwin, who are heirs and successors of our vast estate, sent down from time immemorial. We're here to greet you here on the English Church of England, along with our counselors, our bishops, our officers, our members, as well as we greet you all who are here today trying to get an understanding of what it is that we are trying to do. We want to give special honors to Justice Samuel Alito of Supreme Court. If you're viewing, we want to give honor to you for the encouragement that you're taking and helping us in the anti-disestablishmentarianism against our Church of England. I have a marvelous lesson if you're viewing, so be prepared. So with that, I'm going to digress and let my queen say a couple of words.
Greetings, greetings, greetings. Looking forward to another marvelous lesson. This is going to be a beautiful lesson from the King and the King's Bench. I just want to say I'm thankful for the true diligence of our members. I know it's hard to stay focused, especially in today's times. We're at war with everything today. So I just want to say thanks for your true diligence to the church. And with that, I digress.
Well said, Queen. And with that, Archbishop, you have the floor.
Greetings, everyone. First, I'd like to go ahead and give honor to our King, Clifford Jefferson from Royal House Plantagenet, as well as Queen Godwinson from the House of Godwin, Archbishop Murphy from the House of Murphy, as well as Esquire Burgess from the House of Burgess, and to the rest of the panel, who have shown their discipline to continue to come and do their obligation that they know is traced back not only to our present day, but back to time immemorial. And us as heirs, we just want to do our job that our ancestors have set for us, so therefore we can live in peace and harmony amongst each other here, which we call Albion. For those of you who just had the first time to listen to us, just know what we're doing is, living the life of us as English people, and this information that has always been here. It's just that we have been out of character, and what the King is doing is being able to put the pieces together for us to be able to make ourselves whole again. So with that being said, I digress and get ready, prepare for another beautiful lesson to bring us back together again.
Well said, Archbishop from the House of Belmont. Brother Burgess, greetings, noble. I've seen you come a long way, as well as all those who are counsel, but particularly this young man. Always think about, the cartoons or or movies about a young knight or a young son growing up, timid and unsure of himself, trying to prove himself. And just the unfoldment you have come, bro, speaks for himself, and how humble you are in lieu of that unfoldment. When we dialogue in our private, conversations, you're a beast, and it's like watching when in the Coliseum fight. It's like everybody else on the King's bench. When they look at you, they look at you like you're in the Coliseum, fighting, like, because they've seen you grow from a young boy to who you are now. So it ain't nothing strange. They know how you were before you first started and where you're at now. So now that you're sitting in the stands now and not fighting in the games anymore, we have a lot more respect for you now, because we see where you come from now. Those you may encounter in your private capacity, they're like, man, you ain't all that, but they haven't viewed you in your fighting. And once they undertake that fighting, they know what the example you're going to lay down. So I just want to give honor to you, bro. And we all appreciate you for the encouragement and the courage that you took to follow me and step in my footsteps. And I got great things for you, brother. So without further ado, just give the panel as well as the viewers just a syllabus of how they ought to look at themselves in the light of humanity, and as a result to how we reflect ourselves in the light of humanity, and how we should see ourselves in humanity based off these 7 classifications that we have come to put out, that the world is subject to. And with that, I digress.
I appreciate you, King, and everybody sitting here as well. What you showed to me is that all the answers are really already within ourselves and right in front of us. But a lot of issues is we're not listening to what we're reading or on what's being said. So the truth can kind of go over your head all within itself. And an example of that is, let me think. Me, like I work at Waffle House in my public capacity, right? And I look on the plaque on the wall, and there's a plaque up there that speaks of the real estate representative, the superintendent, and it has another name up there that I can't remember right off. But looking at them misusing the land codes, or misusing the land, excuse me, it shows me what King been saying about how they use an eminent domain to establish what they need to establish in the municipality to continue to usurp us through common recovery. And the fact that I could see that standing within the building and it's right there in front of me, but yet I have nothing to do with it. I have no say-so over it, but yet I'm in that building 17 hours out of a day, and I reap no benefit from it, but it's changing my reality. And it taxed me for it. So that's a reference point of what I mean, well, what King is showing us, well, what's going on within our reality right in front of us that we contribute to. But now that we have the eyes to see, we can do something to correct it, as long as we pay attention to our body of politics that we're applying.
Well said. Well said.
Well
Now,
said,
you remember our conversation when we spoke about the 7 classifications?
Yes, I do.
All right, just give them a little analysis on that. Break that down to them.
Well, when it comes to one understanding something, in most cases, you got the 7 senses they usually. You got history, law, faith, theory, belief, hearsay, and philosophy. So whenever you can't comprehend what one's conveying to you, and you're not using history and law, you're going to default to faith, theory, belief, or philosophy. But then when that don't work for you, you will just break down to hearsay, and nothing matter. It's just basically whatever it is you see, like that emotion. But,
please say that again. Please say that again for the viewers.
So when you're not using faith, theory, philosophy, and belief, you default to hearsay. And hearsay is just based off of whatever your emotions, whatever you feel right at that time, not with any evidence backing it. So to disqualify the other 5, you must use history and law. to get your true understanding of what's being conveyed to you and how it pertains to you in your current life right now.
Well said. Well said. And history and law is one and the same. That's the common law. And we know there's only one common law, and that's the common law of England. So well said, Noble. I really appreciate that. And with that, let's get started. Once again, greetings to everyone. I'm your king. This is your queen, Godwinson from the House of Godwinson. We come to give you a better understanding of who we are as English heirs successors and show you that you are in your estate that was promised to you. The only thing that differs is that you lack the understanding of it. And we're just going to quickly go over it. I'm going to call upon my counselors to read. And I'm going to ask that each and every one of you regurgitate that what I have to say, because it's most paramount to understanding our place and our government. Okay, without that, let's get started. Wikipedia. Okay. Everybody feel okay today?
Yeah.
That's good, King.
All right. All right. I need everybody put on their thinking caps today. I'm trying to go slow. How much time are we working with, Archbishop?
2 hours.
Okay, that should be good enough. Okay. Everybody ever heard of the word anti-disestablishmentarianism?
Yes.
I have not, King.
I have not.
Nobody else have heard of
I've
that?
heard it, didn't know what it meant.
Mhm.
Okay, we're gonna break that down for the world. We know the the root of the word anti-disestablishmentarianism is anti, right? It means against. You got for and against. All right, so let's break down the word of what the word actually means. Let's go to meaning. Now, this for all those who are viewing this, that includes Judge Samuel Alito, as well as all those officials on the Supreme Court, trial courts, municipal courts, attorneys at law, law students, ETC colleges. Y'all really need to take a seat and understand what's being said to you. Anti-disestablishmentarianism is a political position that originated in the 19th century. Britain. The position opposes proposals at the time to remove the Anglican church's status as the established Church of England, Ireland, and Wales, but not in Scotland, which had and still has its own separate national church. Greetings, Countess Harris. When you say established church, you're saying state church or state religion. You're saying the same word. Now they're talking about for against the disestablishmentarianism, they're opposing the dissolving or the dissolution or the disestablishment of the Church of England. Now you have all types of churches of England. We're affiliated with the Church of England, but our affiliation with the Church of England is not of a religious faith. It's not a theocracy. It's not secular. So we're anti-disestablishmentarianism group. But let's break down this word, disestablishmentarianism. Construction of the word. Countess Allen, would you read for us?
The word construction is as follows, succeeded by the number of letters in the word. Establish, to set up, put in place, or institute. Originally from the Latin stare, to stand.
Okay, same word as estate. Status, estate, and standing is the same word. So they said to establish means to set up, put in place, or institute. Continue.
Disestablish, to end the establishment status of a body, in particular a church, given such status by law, such as the Church of England.
Stop. Now, everybody remember the town of Paulette versus Daniel Clark, as well as the propagation of the gospel versus New Haven. We remember those two cases, right?
Yes.
Yes.
And they were based off establishing churches for the greedy eyes of soil, i.e. for the land. But the sus quate aspect of that trust was not fulfilled. So that meant that neither religious society or group could inherit the land. Because it said in the case that the Church of England was dissolved in the United States as it was did in Britain, as established by law. And we know history and law is one and the same. So we're not talking about the other 5 elements as stated by Brother Burgess, Esquire. And we're not talking about hearsay. Continue.
Disestablishment, the separation of church and state, specifically the goal of the political movement of the 1860s in Britain. Disestablishmentarian, one who subscribes to said movement. Anti-disestablishmentarian, one who opposes the said movement. Anti-disestablishmentarianism, the movement or ideology that opposes disestablishment. The word construction could be lengthened further in many ways. For example, anti-disestablishmentarianism is strictly doing something with anti-disestablishmentarian intention.
Okay. So what we're doing, that we're trying to stop this disestablishment of our Church of England, right? So we're anti-disestablishmentarianism society. To be that, you must not be secular. Because secular, you don't care if they're religion, you don't care if it's not. That's what you call separation of church and state, secularism. Everybody follow?
Follow.
Before there was secularism, there was a state church or a state religion or a state society governed by a state government. Everybody follow?
Follow.
Okay, let's get a little bit more deep into that word. Anti-disestablishmentarianism. Read that, Sister Queen, Countess.
Anti-disestablishmentarianism is a position that advocates that a state church, the established church, should continue to receive government patronage rather than be disestablished.
Okay, everybody take in mind the town of Paulette versus Clark, Daniel Clark, and the propagation of the gospel versus New Haven, which goes all the way back to Bennington Wentworth, dealing with the land use that was created by the grants given by Bennington Wentworth, when it fell under the jurisdiction of the grant given by Charles II to Duke of York on March 12, 1664. Prior to that, it was governed by New Netherland, under the Dutch. Good, Queen? Under the Dutch. Continue.
In the 19th century Britain, it developed as a political movement in opposition to the disestablishmentarianism, the Liberal Party's efforts to disestablish or remove the Church of England as the official state church of England, Ireland, and Wales. The church's status has been maintained in England, but in Ireland, the Anglican Church of Ireland was disestablished in 1871. In Wales, 4 Church of England dioceses were disestablished in 1920 and became the Church of Wales. In colonial America, the Church of England was disestablished in 6 colonies, despite its mild popularity in Anglicanism in the 1780s, and many former Anglicans deemed themselves Episcopalians instead.
Everybody hear that?
Yep.
So when we go
Yes.
back to the town of Paulette versus Daniel Clark and the propagation of the gospel versus New Haven, which Benjamin Winsworth was associated with, it clearly stated that they never felt the obligations of the Statutes, fit the description of the Church of England, because in that case, it specifically said it must be a corporation soul, which we are as incorporated. Everybody follow?
Wow.
Follow.
Okay, let's go. Can we save our remarks for the sake of time? Thank you. History. Continue to read that.
The matter of disestablishment of the Church of England is an ongoing issue, often tied with the position of the monarchy of the United Kingdom as supreme governor of the church. See the Settlement Act of 1701.
Okay, so in regard to anti-disestablishmentarianism, this was brought up in regard to the Church of England, going back to the time of Henry VIII, who put all the church assets into a trust. That's why the church was kept alive and held in a trust and a statute for the proper Church of England to come forward. Because we know under those 2 cases, the land and the assets belonging to the church, i.e. the property, was under statutes of mortmain, which means a dead pledge. As the church died, the property will stay with the church. And it was established under the Settlement Act of 1701 in regards to Henry VIII marrying Anne Boleyn, and all the property that belonged to the church he used for it. That's why they brought up the issue of dissolving the Church of England. Just brought up what we call the supreme governor of the church. The supreme governor of the church took the place of the monarch, because the title supreme governor of the church is the same as the monarch under a rump parliament. Let's prove it. All right, just click this. Supreme Governor. The Supreme Governor of the Church of England. Supreme Governor of the Church of England is a titular head of the Church of England in a position which is vested in the British monarch. Everybody see that?
Yeah.
And who is the head of that? Charles III. So they call him the Supreme Governor. He's not the monarch. He's not the Supreme Governor. Why do I say that? Because he's just a titular, a behind-the-scenes ceremonial leader. We're going to prove this. Let's go ahead. I thought I said it. Let me just pull this up right quick. Government. Y'all bear with me. I got a lot of ground to cover. Colonial government. Oh no, that was the wrong one. Right. Okay, we're talking about the supreme governor. It's the same as the British monarch. All right, let me share my screen. Now, the monarch was ruling in the days of the colonies, right? We're specifically talking about the middle colonies, which is called New Jersey. You got the northern colonies, southern colonies, and the middle colonies. All right, we know that when they declared their independence, it was in the middle colonies, but New Jersey was one of them, because they declared their independence on July 4th, 1776. But New Jersey created their constitution on July 2nd, 1776. So they created the constitution, then 2 days later, they declared their independence from Great Britain. Everybody follow?
Follow.
In the days of the colonies, the province of New Jersey was ran under what they call the New Jersey Provincial Council. New Jersey Provincial Council was replaced with New Jersey Provincial Congress, which was established by 13 counties, not states, not colonies, but 13 counties established New Jersey Provincial Congress. 13 counties. You got 21 counties in New Jersey. You got 566 municipalities. But 13 of those counties where the 566 municipalities added all the 21, they created a provincial Congress at that time. Before that, it was ran by the Provincial Council under the Crown, which I'm gonna show you. The colonial government in the 13 colonies, they declared the government of the 13 colonies of the British America, they ain't talking about England, developed in the 17th and 18th century under the influence of the British Constitution. When the British talking Constitution, you're talking about those that come under the Bill of Rights of 1689. And everything that preceded the Bill of Rights, just that those that composed of in the Magna Carta, which is real protected through our certificate of incorporation. Because right now, we're not functioning under the Parliament of the English Parliament. We're functioning under the British Parliament under the Commonwealth, which developed in the 17th and 18th century under the influence of the British Constitution. After the 13 colonies have become the United States, the experience under the colonial rule would inform and shape the new state constitution and ultimately the United States Constitution. Everybody follow?
Follow.
So New Jersey State's Constitution was established and predestined for the creation of the United States Constitution, which governs all the states in the United States. Everybody follow?
Follow.
Continue to read, Countess.
The executive branch was led by a governor, and the legislative branch was divided into two houses, a governor's council and a representative assembly. In royal colonies, the governor and the council were appointed by the British government. In proprietary colonies, these officials were appointed by proprietors, and they were elected in charter colonies. In every colony, the assembly was elected by proprietary owner, property owner.
Okay, let's go a little further. Where is it? Okay, right here. Relationship to the British government. Now we're talking about royal governors in relation to the royal governors here in the United States. In the States, well, and you didn't have any royal governors in the United States. The only royal governors you had here in the United States was the first one, Viscount Cornbury, and the last one, William Franklin, the legitimate son of Benjamin Franklin, before they moved it to an administrative law by way of William Livingston when they moved the capital city from Perth Amboy to Trenton, right? And Trenton is the seat of the government, which is the municipality. Now read this relationship to the British government in terms of what we call the royal governor or the supreme governor, which, as we read, was similar to the British monarch, supreme governor. We'll go back here. We're talking about anti-disestablishmentarianism, and the history goes back to the matter of establishing the Church of England is an ongoing issue, and it tied was to the position of the monarchy of the United Kingdom as supreme governor of the church. See the Act of Settlement of 1701. Let's just hit that real quick. Act of Settlement. Everybody see that?
Mm-hmm.
Now, Viscount Cornbury, the first governor of New Jersey, was the governor of New Jersey in 1701. Under the crown, under the Provincial Council in the province of New Jersey. This is the time of the Act of Settlement. The Act of Settlement is an act of the Parliament of England. So that means that the Parliament of England was here at that particular time, under the crown. That settled succession to the English and Irish crown to only Protestants, which we know are associated with the Episcopalian Church. Because the polity of the Church of England is Episcopalian. Everybody agree?
Follow.
All right, let's go back here. Okay, just to make sure we go back to Church of England, just to show it, show everybody. Church of England. You go to the box, it says it's polity, Episcopalian. Everybody see that?
Oh.
Region, England, Wales, Isles of Man, Channel Island, continental Europe, and Morocco. It covers all that vast jurisdiction, the polity or the church state. At that particular time, it was under de facto monarchs, but it was still a church state under the jurisdiction of the crown before it became secular. All right, let's go back. All right, so we've seen the Act of Settlement, and we understand that the supreme governor of the Church of England was actually the British monarch, because there's nothing more than a ceremonial head or a titular. They were not actually the king of England. They were not the king of England. Let's go further. New Jersey Provincial Council. Quick history lesson for all those who don't know this history. New Jersey Provincial Council was the upper house of the New Jersey legislature under colonial rule until it was replaced by New Jersey Legislative Council under the New Jersey Constitution in 1776. Everybody see that?
Yes.
Follow.
Follow.
So if we look in the box, the body of politics under a state church or a state religion had 12 seats, political group, local faction. The list in terms of that council was indefinite and the authority was under the crown. Alternative jurisdiction, Burlington and Perth Amboy. These were not municipalities at the time, because municipalities are under administrative law. When the United States and the states incorporated, it was under administrative law. When you go to a court of law, in a court dealing with courts of law, it's administrative. It's not constitutional. Everybody follow?
Uh-huh.
All right. Before it was, after it was the New Jersey Provincial Council, it became the New Jersey Constitution. Let's find out why. Read this history real quick, Councilor Allen.
History. The Provincial Council was established in 1702 under the surrender by the proprietors of East Jersey and those of West Jersey of the right of government to Queen Anne. Anne's government united the two colonies as the province of New Jersey, a royal colony, establishing a new system of government. The instructions from Queen Anne to Viscount Cornbury, the first royal governor of New Jersey, outlined a fusion of power system, which allowed for an overlap of executive, legislative, and judicial authority. It provided for bicameral legislative consisting of a council of general assembly.
Stop. So if they talk about a fusion of power, then that's not secular, is it?
No,
Because secular will be separation of church and state.
this was continued.
This talk about a fusion of power under the monarch, and the monarch governs the church. Continue to read.
On December the 6th, 1775, Governor William Franklin prorogued the New Jersey legislature until January the 3rd, 1776, but it never met again. On May 30th, 1776, Franklin attempted to convene the legislature, but was met instead with an order by the New Jersey Provincial Congress for his arrest. On July 2nd, 1776, the Provincial Congress approved a new constitution, and on August the 13th, a new legislature was elected, with the appointed Provincial Council being succeeded by the elected New Jersey Legislative Council.
Ooh, this is heavy. This is heavy. I hope you're watching this, Supreme Court. Look what they just said. The Governor William Franklin, the illegitimate son of Benjamin Franklin. This was the one who granted the charter of Rutgers College. Rutgers College is called Queens College. New Jersey created their 1947 Constitution in the college dorm of Rutgers University. And how could you do that when the actual territory of the college was granted by William Franklin, who was the supreme governor under the monarch, because the provincial council was under the crown. So if the king or queen wasn't there, then the supreme governor was next in line. If you wasn't talking to the king or queen, you talked to the supreme governor. Because that was for the anti-disestablishmentarianism. It said that dealt with the disestablishment, anti-disestablishment of the Church of England. Didn't it say that? Headed by the supreme governor or the British monarch, because they were corresponding, both roles were interchangeable. Let's just go back to it. Colonial government. It says, by the start of the American Revolution, the 13 colonies had developed a political system featuring a governor, exercising executive power and bicameral legislature made up of the council and assembly. The system was similar to the British Constitution, with the governor corresponding to the British monarch. So what does corresponding mean?
Okay.
Relating to. That means they had the same functions, the same duties. The royal governor was the supreme governor, or as we should say, if it was under the monarch himself. If you don't believe me, let's go to the Constitution. Since they said that under the Constitution, where do we at? New Jersey Provincial Council. The New Jersey Provisional Council locked up William Franklin, who was the supreme governor, because why? He was a royal governor. A royal governor is a supreme governor. A regular governor is just an administrative governor. He's only governed under under police powers, under eminent domain, and we're going to show you under the New Jersey Revised Statute where he's governed under the state's government. And the statute, Title 52, Section 14B1 in New Jersey. All the other states is irrelevant because we know New Jersey state changed from colonies to state on September 20th, 1777. So what they did is just grant their powers to the municipalities, which is nothing more than an administrative bureau. Because bureaucracy is administrative agencies who are non-elected. All right.
So
Let's
he
see
was
here.
the last royal governor to serve on the provincial
William
council.
Franklin.
Mhm.
The first world governor was Viscount Cornbury. The first one. We got him here. Let's go here. Where he's at, right here. The instructions from Queen Anne to Viscount Cornbury. This is Viscount Cornbury. Governor of New Jersey, what year? 1701.
Mhm.
Now we're talking about the Antidisestablishmentarianism that made reference to the Settlement Act of 1701. Didn't it say that?
Yeah.
Yes.
Now we're dealing with 1701 under the government of Queen Anne here in New Jersey and British North America in 1701. And he's the first world governor of New Jersey under the colonies. Not no states yet. They're not states. Everybody follow?
Follow.
Any questions? I guess not. Let's move forward.
I have a question.
Go ahead.
So can you go back to that page again?
Say it again.
Can you go back to that page again? Can you refer back to that page again so I can?
Go ahead.
Okay, so you said the first governor of New Jersey. I thought you said it was Viscount Cornbury.
This is him,
Oh, the third Earl. Okay, I follow.
Earl of Clarendon.
Yeah, the Viscount Cornbury, that's the title,
That's the title.
but his name.
This
is
guy
Edward
right
Howard.
here was the one who helped Charles II restoration to the crown. This guy right here. He was restored to the crown in 1660. He recovered New Jersey from Netherlands on March 12, 1664. That's the province of New Jersey. Let's just go to it. We know that the provincial council is the crown. Let's just qualify it. It says it right here, the crown. And we know what the crown is, the corporation soul.
Mhm.
Right? Now, if the crown was succeeded by New Jersey state legislator under New Jersey Provincial Congress, let's just go there right quick. New Jersey Provincial Congress. New Jersey Provincial, read this, Countess.
The Provincial Congress of New Jersey was a transitional governing body of the province of New Jersey in the early part of the American Revolution. It first met in 1775 with representatives from all New Jersey's then 13 colonies to supersede the royal governor.
Stop. Did you hear that?
Mhm.
So what did Brother Berger say? We're not listening to what's being said. We're not listening to what's being said based off the history and law. To that, people don't care. So when it's based off theology, philosophy, or the other three he mentioned, and when people get tied up because you're never going to get no truth out of it because there's no history and law to support it. So because of that confusion and bigotry, they left up the hearsay. Whether you're in the individual or whether you're in the collective, you're better off being in the individual, because at least you have time to reflect. You can reflect better by yourself than a bunch of people whispering in your ear. No, this is right, man. No, this is right. Man, we don't know what's right because there ain't no law in history to support what's right. And if there is no history of law, then it's all hearsay. Why? Because it's secular. God ain't in the picture. We're about to get into that. We're about to break that down. So he said, go ahead and read. So you read it. So it says that they took the place of the royal governor. Now you just got governors now. And where did they move the seat? Trenton. Okay. Trenton is a municipality. It's a municipality. Y'all don't believe me? Let's check it out. All those who think we don't know what we're talking about, Justice Alito, I'm showing you. Everybody see that? This is 2013 and it's also in 2021. Don't make it different what year you pull up. It's always been here. State government, departments, and officers. Everybody see that?
Yeah.
Mm-hmm.
It says this act should be known and may be cited as the Administrative Procedure Act. Everybody see that?
Follow.
So I'm not just talking about this state. I'm talking about any state and any state in the United States. You're governed by an Administrative Procedure Act. They call it the New Deal.
The New Deal.
Yeah, okay. Wow.
That's what they call it, the New Deal. All right? So we know the first world governor was Viscount Cornbury, and we know that the last world governor was who?
William Franklin.
And William Franklin held on to the crown property before it was dissolved and disbanded, dissolution, and held it in the trust under anti-disestablishmentarianism. Because it said under the town of Paulette that the United States dissolved the Church of England as established by law, just as the British government did it as established by law. But it was held in the Statutes trust and in lieu of a corporation soul. The corporation soul represents the crown, because that's what the crown is, a corporation soul. So that means that the state government we're reading here is not a corporation soul. It's an administrative procedure agency. It's a bureaucracy. Let's look it up.
APA, that's what they call the fourth branch of government.
The fourth branch of government. The secret hand of justice. 1 second. My screen acting up. Give me 1 second. Everybody see that?
Yeah.
Yes.
Yes.
Okay. Bureaucracy. The term bureaucracy refers to a body of non-elected governing officials as well as to any administrative policy making group. Everybody see that?
Mm-hmm.
Yes.
That's a legal definition. Historically, a bureaucracy was a government administration managed by departments staffed with non-elected officials. I'm not making that up. We're not making this up. And they ain't making it up. They saying this is their government.
Your local
Let's go
government.
back to the statute. Administrative Procedure Act. So let's go, we're in Title 52. Let's go to the first statute of the administrative government. And what does it say? 52:1-1. State government, read what that says, Countess Middleton.
Yes. Trenton seat of government, location of legislative sessions. Trenton in the county of Mercer shall be the seat of the government of this state. All sessions of the legislature shall be held at Trenton or on a temporary basis for ceremonial or commemorative purposes at such other place in the state as shall be designated by the legislature by concurrent resolution.
Okay, so how you hear it is let you know that the Trenton seat of government is administrative because it sits in the municipality. And the municipality is administrative government, policy-making group that are not elected.
Mm-hmm.
As any state in the United States of the United States government on all levels. Everybody follow?
Follow.
Okay.
Clear.
I hope y'all are.
Which
Okay,
means
let's get
that they are foreign.
foreign. You're exactly right. Now let's go to the Constitution. Everybody see that?
Yes.
This is on the Department of State's website. This is not random. This is from their website. Bear with me, my screen is freezing. 1 second. Bear with me. Sorry, Queen. I'm gonna have to get back to the website, Wikipedia. Y'all bear with me. You can turn back. Okay. For all those viewing, this is Department of State's Constitution. 1947 Constitution was established in Rutgers University. Rutgers University was called Queens College, and they created the 1947 Constitution in their gymnasium. And the charter given to that institution was by William Franklin, the royal governor on the jurisdiction of the crown. So for one, that makes New Jersey's Constitution in 1947 and 1844 de facto, does it not?
Yes.
Because you were succeeded by the crown having jurisdiction over that territory under the New Jersey Provincial Council and the New Jersey and the province of New Jersey before you created the New Jersey Provincial Congress out of 13 counties. Everybody follow?
Follow.
Let's
Follow.
go back there. Seven. 76. Let's get some confirmation on the website about the United States government under the crown. Everybody see that?
Yes, I see it.
Okay, now we know Title 52, Section 14B1 deals with the state's government And we know that 14B1 deals with the Administrative Procedure Act. So that means anything dealing with the Administrative Procedure Act governs their laws and governs their courts. Everybody follow?
Follow.
That makes, because that's what they did to protect that property that don't belong to them, because it's only based off land use under eminent domain powers, which is called fee and simple. Before we get into that, let's deal with that. This is 1776 Constitution of New Jersey. After they disestablished the crown under the Provincial Council, which was led by Parliament under the Westminster parliamentary system, they dissolved that when they created their constitution in July 2nd, 1776. We're reading now. And then they declared independence on July 4th, 1776. Everybody follow?
Follow.
At the hands of who? The executive officer. Let's go to the executive officer. Article 8. Right here. Everybody see that?
Yes, follow.
It says that the governor, or in his absence, the vice president of the council, shall have supreme executive power by chancellor of the colony and act as a captain general and commander-in-chief of all militia and other military forces in this colony, and that they are 3 or more of the council. And it should be at all times be a private council to advise the governor in all cases where he might find it necessary to consult them. That the governor be ordinary and surgeon general. 9, that the governor and council be the court of appeals. This is the Supreme Court, y'all. What does it mean to be the supreme governor? Means the head shop who controls everything. To review supreme governor, and it says in the British monarch, it was the same as the monarch. Didn't it say that?
Yes.
So if in the Commonwealth under the British monarch, it's the same as the world governor, then hell, you don't need no attorney general to represent you, do you? Because you're the supreme governor. You're not the supreme governor now because you govern under administrative law. And administrative law versus constitutional law is 2 different things. The administrative law is governed under the Administrative Procedure Act, which governs the civil rights that govern the people. Under constitutional law, it governs the Bill of Rights of 1689, the Constitution of the United States, and the Constitution of New Jersey. Because if it wasn't for the Constitution of New Jersey, you wouldn't have no Constitution for the United States. Everybody follow?
Follow.
So it's just said right here, that the governor, it's a supreme executive power. Right here. Now, if you read in 1844 and 1947, they took out the word supreme and left executive power. Because executive power is where the administrative law was created by the governor. Everybody follow? Let's go ahead. First, before we go into that, let's look up secular state. Let's look at that now, first of all. Okay. Section 4055D1. It says this is the act may be cited as referred to the municipal land use laws for municipalities and counties. So they all using land use laws. We know land use laws are laws that they're used to manage or modify the natural environment to create new environments and new settlements based off land zoning, land marketing, or what we call regulating taking laws. Regulated taking laws are called land use laws for using land under what we call police powers through eminent domain. Eminent domain is a nice way of saying land acquisition. Same word. Back in them days, they called it right of conquest. Then it became law of discovery. Then it became quiet rent. Then it became land use. Everybody follow?
Follow.
Follow.
Let's look at eminent domain. It just said it right here. Everybody see that? Everybody see this?
Yes.
Yes.
Well, eminent domain means land acquisition. When your house is sold for foreclosed, it's put up for land forfeiture under what they call land acquisition. Am I right?
Follow.
All right. Let's go to the origin of land acquisition. Eminent domain.
Our King, at the top, is that all the countries that participate in the eminent domain that's being listed?
No, these are the countries, what they call it different things.
Okay.
So some call it land acquisition, some call it compulsory purchase acquisition, some people call it resumption. We call it right of reversion of a state. We revert the state back to the original owner as a result of eminent domain or land acquisition, which is nothing more than fee simple. Some jurisdictions require that the taker, under taker regulations, make an offer to purchase the subject property before resorting to the use of eminent domain. However, once the property is taken and the judgment is final, the condemner owns it free and simple and may put it to use other than those specified in eminent domain auctions. Because it might be subject to what they call easements, encumbrances. Everybody follow?
Follow.
Okay. Another word, statute. Now this is Title 52 on the administrative procedures for the state government, actions or torts against the state. It says here, except for actions founded upon the Constitution of the state or the United States or an express provision of the statutory law of the state, no action shall be instituted or continue against the state or any department or other agency thereof for the recovery of money damages based on torts where the cause of the action occurred prior to July 4th, 1972. So they let you know that if your argument is based off the Constitution or the laws of the United States or any statutory law, you can't sue the administrative, the courts or the administrative officers of the courts under administrative law. Why? Because you their property. You can't bring a claim against them if it's not based off the Constitution of the state or the United States. But we know the state's government of every state is not governed by the Constitution because they go according to some Administrative Procedure Act. Let's find out what that is. Let's see. Read that right quick, Countess Middleton.
Yes, constitutional law versus administrative law. Constitutional law refers to laws that are related to the rights and responsibilities of the different branches of a state government. They describe how laws are created and interpreted, as well as how the supreme leader of the executive branch of a government should act. This is the basic law upon which all other laws of a state are created. Examples of constitutional law include,
Stop now. It says how the supreme leader, who is the supreme leader of the executive department? The governor.
The governor, yep.
But he's not acting under the constitutional, so he's not going to call himself supreme leader. He's an executive leader, but he's not functioning under the Bill of Rights, under the state constitution, or the United States Constitution. Because if that was the case, he would be the supreme leader. He's only administrative leader. Now, we just said the examples of constitutional law under constitutional courts are the state's constitution, the United States Constitution, or the Bill of Rights. And the Bill of Rights is the Bill of Rights of 1689. That's before 1701, am I right?
right?
Mhm.
We know 1701 deals with the anti-disestablishmentarianism of the Church of England. Continue to read.
Administrative law describes the ways in which bureaucratic agencies can fulfill the operations and responsibilities of their branches. Some experts consider administrative law to be a division of constitutional law because bureaucratic branches act under the delegation of the main branches of a government. Thus, the administrative law is created to help bureaucracies function within the parameters of the state government as defined by constitutional law. Examples of administrative law include the Food and Drug Act, the Administrative Procedures Act of 1946, the Fair Housing Act, the Civil Rights Act of 1965.
Stop. So we know the purpose and the relationship. You just read the purpose and the relationship to a constitutional law governing the constitutional court for constitutional people versus administrative law for administrative courts for administrative people and their citizens. Everybody see the difference? Now we know our state's government, as well as every state government that's not under the colony, because if you were subject to the colony, you would be under the protection of the crown. And we know the crown goes back to the Bill of Rights and the Constitution, as well as the Constitution of the United States. Because if you're not talking about that, then you're dealing with non-elected officials under the administrative law, which is those laws that created or administered from Trenton, New Jersey. When the Provincial Congress, 13 counties out of 21 counties, created a Congress de facto and created it and moved it to Trenton. And the seat of Trenton is in Mercer County. And the Supreme Court of Mercer County is in Richard Hughes' building. Richard J. Hughes. Let's find out who this guy is. Read that, Countess.
Richard Joseph Hughes, August 10th, 1909 to December 7th, 1992, was an American lawyer, politician, and judge. A Democrat, he served as the 45th governor of New Jersey from 1962 to 1970, and as Chief Justice of the New Jersey Supreme Court from 1973 to 1979. Hughes is the only person to have served New Jersey as both governor and Chief Justice. Hughes was also the first Roman Catholic governor in New Jersey's history.
Stop. Okay. The court building was Supreme, it says here, it was New Jersey Supreme Court in 1970. Right? He's in office now. He was the 45th governor. I was born January the 14th, 1970. Now, the first royal governor or supreme governor was Viscount Cornbury under the crown in Providence, New Jersey, under provincial council. Before it was under disbanded by a New Jersey state legislature by 13 counties and moved the seat of the government to a municipality in Trenton, New Jersey. And the Supreme Court is governed in the 1947 Constitution under Article 4, Section 7, Paragraph 1. That's where the Supreme Court of New Jersey gets their authority from. And if you look under Rule 1:33 of the administrative law of New Jersey, it governs the Supreme Court, and it's called administrative responsibility. So you have moved administrative responsibility from the Constitution to administrative under the administrative rules. Rule 133. That makes sense to everybody.
Follow.
Okay, under this Governor Richard J. Hills. Now let's check out now the federal regulations under the new deal are published in what they call the Federal Register. New Jersey administrative rules are governed under what they call New Jersey's Journal for promulgating regulations and rules for administrative agencies and departments. Everybody follow?
Follow.
Okay, so let's get an idea of this guy. This is the New Jersey Register. New Jersey, Thursday, September 25th, 1969. Let's go back here for a minute. Y'all see this? State government.
Yeah.
This act should be cited as the Administrative Procedure Act, effective September 1st, 1969. It was created on my birthday, January the 14th, 1969. But it didn't become effective till September 1st. Everybody follow?
Follow.
And let's go to this article, because all administrative governments laws are published in what we call the New Jersey Journal. This is the first established publishment of the New Jersey Journal under this judge, Richard J. Hills, where the Supreme Court building sits. The building is named after this guy, who was the 45th governor of New Jersey in 1970. 45th governor of New Jersey and the first and the governor of New Jersey. Let's go ahead. What was I at? This is the New Jersey Register. It's their journal. Can you see this, Countess Middleton?
Yes.
Read. Let me blow it up so you won't have to strain. All right, start from reading here.
The New Jersey Register, printed and distributed by the New Jersey Law Journal, designated by the Department of State, Division of Administrative Procedure, pursuant to the Administrative Procedure Act, Chapter 410, Laws of 1968, as the official organ for publication of the New Jersey Register. A periodic bulletin of rules and regulations, files, and notices
Where you
issued. Oh, over here to the definitions. Okay.
Hold on 1 second. I'm trying to find out where were you reading from?
Just above, message from the governor. Yeah, right here.
Okay. Let's see.
Okay.
You have message at the governor now? Did
Yes.
you read this right here?
Yes.
Okay.
I read that.
Read it again. Read that for me.
Printed and distributed by the New Jersey Law Journal, designated by the Department of State, Division of Administrative Procedure, pursuant to the Administrative Procedure Act, Chapter 410, Laws of 1968. As the official organ for publication of the New Jersey Register.
Read the statute. Read that statute.
Oh,
we just
okay,
went that. This is the same statute here, y'all.
okay,
That's the same
NJSA,
statute, everybody.
right.
Okay. Let's go back. Go ahead.
NJSA 52:14B-1 at sequester. Sequence as the official organ for publication of the New Jersey Register, a periodic bulletin of rules and regulations filed and notices issued by the administrative agencies of the state.
Okay. He just now this is the first published article of New Jersey Register where administrative laws are published. This is a message from the governor. Now, we just read the New Jersey Revised Statute that reflects this message because the administrative statute came effective September 1st, 1969. Now, read what this says. It says it under the revised statute, and it says in this article. Continue.
Message from the governor. The publication of this first issue of the New Jersey Register marks the official initiation of the Administrative Procedure Act of 1968 and constitutes the implementation of a program officially conceived more than 20 years ago. New Jersey's 1947 Constitution provided the legislature shall provide for the prompt publication of all administrative rules and regulations.
Stop. Now, it doesn't say that. It says New Jersey 1947 Constitution provides the legislature to provide for the prompt publication of rules and regulations. And it say nothing about all administrative. Nothing in there whatsoever about all administrative. So why would the message governor put administrative when we're about to read that it's unconstitutional? Supreme Court is going to rule that administrative proceedings are unconstitutional. So if the Supreme Court ruled that it's unconstitutional, then how could the governor back in 1969 make this argument? Continue to read.
Okay.
Right here.
Now, with the publication of this register, New Jersey can provide an official, continuing, and comprehensive source of information about the activities of its state agencies. This capacity I have urged to assure public confidence in the activities of its governmental agencies. Public participation in the making of the rules which affect us all will be encouraged and simplified by the availability of this periodical. Until now, only the federal government and one state among all the jurisdictions of this country have attempted a single official publication, gathering together all the information necessary to an informed public. I am pleased New Jersey has now taken this progressive step, and I urge all those who deal with government to accept this challenge of involvement. It is with great pride that I join in taking special note of this occasion and in commending those who have participated in this significant program.
Okay, here's his name, Richard J. Hills. So you just said that you're calling on all participants to take hand in the disestablishmentarianism of the Church of England. Because for one, there's a separation of church and state, right? There's a separation of church and state, and now you're not even functioning under the Constitution, which protects religious rights. Because now you're subject to administrative review under the administrative government imposed in New Jersey. When New Jersey was subject to, we just read the two differences between the administrative government and the constitutional government. The administrative government functions under the what? The Procedure Act, under that statute we just read, Title 52, 14B1. Our constitutional government governs under what? The state's constitution, the United States Constitution, and the Bill of Rights of 1689, and all those rights that precede it, going back to the Magna Carta. Everybody follow?
Follow.
Follow.
So administrative state is the United States and the states without the crown. That started in 1776, that the disestablishment of the crown, because the crown governed the Church of England. We just proved it by Queen Anne, province of New Jersey. The province of New Jersey was in 1664, right here. They didn't read that. Continue to read this.
Later in 1664, the Duke of York gave the part of his new possessions between the Hudson River and the Delaware River to Sir George Carteret in exchange for a settlement of a debt. The territory was named after the bailiwick of Jersey, Carteret's ancestral home. The other section of New Jersey was sold to Lord Berkeley of Stratton, who was a close friend of the Duke. As a result, Carteret and Berkeley became the two English lords proprietors of New Jersey. The two proprietors of New Jersey attempted to attract more settlers to move to the province by granting sections of lands to settlers and by passing the Concession and Agreement, a 1665 document that granted religious freedom to all inhabitants of New Jersey. Under the British government, there was no such religious freedom, as the Church of England was the state church. In return for the land, the settlers were supposed to pay annual fees known as quit rents.
Okay, so let's let you know that the state church or the state religion is the Church of England. Without that, it's just secular. All right, let's go back to anti-disestablishmentarianism. This is our focus. Okay. Now it just said, it says that in 19th century, there was the anti-disestablishmentarianism established to counter the establishment of the removal of the Church of England. Now we know under Dartmouth College versus Woolworth and propagation of the gospel that the Church of England was disbanded, dissolved by law in the United States and the British government. So that means that there ain't no state church, right?
Mm-hmm.
All those monarchs under the monarch gave it back, and the United States became successor of it to the crown. But they're not functioning under the crown. How you going to become successor of the crown but not function under the crown? That's a violation of law. We know you ain't functioning under the crown because you moved it to Trenton under administrative law. Prior to that, it was under the crown, under protection of the Provincial Council and Perth Amboy, under the province of New Jersey. Everybody follow?
Follow.
Follow.
Okay, let's go here. Let's get a little more in depth on why this happened. First, let's read this part. This is a case Fifth Circuit holds Security Exchange Administrative Proceedings unconstitutional. Now, Security Exchange Commission came from the New Deal. All those are fall under what they call the administrative acts. All issues dealing with those officers of the Security Exchange Commissions are subject to administrative proceedings. But under those administrative proceedings, they deny due process of law. And why? Read what this says. Read this, Countess Middleton, from here to here. I'm not going to go into the whole article for the sake of time.
In a 2-to-1 ruling, the panel in Jarcasi versus SEC number 20-61007, 2022 US APP Lexus
You can
13460
skip all that. Don't read that.
concluded.
Hold up. Remember the date, May 24th, 2022, y'all.
Okay,
This is May 24th, 2022. Now we know that administrative law is based off municipal law, which in New Jersey, it was in Trenton. In the United States, it was in Maryland, called the District of Columbia. That is administrative division. Everybody follow?
Follow.
Prior to that, all that was Crown Colony under the jurisdiction of the Crown. Under the jurisdiction of the Supreme Governor, under authority given by the minor. Everybody follow?
Follow.
Now read what, continue to read.
Concluded that administrative enforcement proceedings before administrative law judges suffer from 3 independent constitutional defects. First, they deprive the accused of the 7th Amendment right to a jury trial in an Article 3 court. Second, they constitute an improper delegation of legislative power in violation of Article 1's vesting clause. Third, they are adjudicated by inferior officers who are statutorily insulated from executive removal in violation of Article 2's Take Care clause. Accordingly, the panel vacated the SEC's decision and remanded the case for further proceeding.
So they're letting you know that any administrative proceedings under the authority in the administrative court tried by the administrative judge is unconstitutional for those 3 reasons. 1, they violate the appointment clause. 2, they violate the take care clause. And 4, they violate the due process of law for a trial by jury, which is all granted by the Constitution. Everybody can confirm that now one of us have been to a trial by jury in our own parish. Am I right?
All right.
Correct.
All right, let's find out why. Before we do that, let's find out the difference between a state religion and a secular religion. Or a state church and a secular state. Read that, Countess Allen. Greetings this morning. Good to see you, Countess Allen.
Yes, good to see you too, King.
Okay, you didn't get a chance to read, did you?
I did, I read first.
Okay, I meant to say Countess Walker. I apologize.
Okay.
Greetings, Countess Walker.
Greetings, King. Greetings, everyone.
Good to have you here today.
Thank you.
You're welcome.
A state religion, also called a religious state or official religion, is a religion or creed officially endorsed by a sovereign state. A state with an official religion, also known as a confessional state, while not secular, is not necessarily a theocracy. State religions are official or government sanctioned establishments of a religion, but the state does not need to be under the control of the religion, as in a theocracy, or in a state-sanctioned religion necessarily under the control of the state.
You hear that? Read that again.
A religion or creed officially endorsed by a sovereign state, a state with an official religion, also known as a confessional state, while not secular, is not necessarily a theocracy. State religions are official or government sanctioned religious establishments of a religion, but the state does not need to be under the control of the religion, as in a theocracy, nor is the state sanctioned religion necessarily under the control of the state.
So that means that A state church or a state religion is sovereign to itself. It's not based off of religious faith that makes you subject to that faith, everybody who believes in it. Nor is it subject to the state, which is secular, which don't care about no religion, because the body politics is not subject to that religion, because there is no body of politics associated with a religious faith, because it's all faith, it's abstract. But a religious state is different, because a religious state is a state church because it was subject to the crown, which is subject to the king's body of politics. So in order to have a state polity, you must have a state church. Because we look in the screen, we look in the diagram up here, it gives you an example of state church or state religion. You see any here in North America?
No.
You see it over here and the other countries, but you don't see it here in North America. So this is state polity. Prior to the state of the United States or the state, there was a state religion here. Let's go to secular. Excuse me. This is a secular state. Now you look at the map here. It's all lit up in blue. States with no state religion, states with state religions is red. Ones with no state religion is blue. Now you see red got a state religion or a church state or a state polity. In North America, it ain't got none. So this must be hell. It's gotta be hell if there's no state religion to govern the actions of the people. And we know that in a state religion, it had nothing to do with secular nor theocracy, or belief, or religious faith. Because you can have a faith, but the politics is not there, which means it's just nothing more than a worship, which means religious freedom. Does that make sense to everybody? Let's find out how we got in this situation, y'all. Because as we can see, in New Jersey, when we go to the Supreme Court, they're going to make a distinction based off administrative law as established by Richard J. Hughes, who was the 45th governor of New Jersey, who descended down from the governor, William Franklin, when they overthrew the crown, who was protected by William Franklin, the last world governor, who descended from the first world governor, Viscount Cornbury, under the authority of the crown, under the province of New Jersey, under the authority of the crown as a provincial council. Everybody follow?
Follow.
All right, let's find out how we got into this. Where is it at? Okay. Let me just show you one more thing. State religion. Now we know a state religion had a religious creed. Let's go down to disestablishment. Read this part right here.
Types: the degree and nature of state backing for a denomination or creed designated as a state religion can vary. It can range from mere endorsement with or without financial support, with freedom for other faiths to practice, to prohibiting any competing religious body from operating and to persecuting the followers of other sects. In Europe, competition between Catholic and Protestant denominations for state sponsorship in the 16th century evolved the principle, Archbishop?
Cuius regio eius religio.
Go ahead, Scott. I would have said the same thing, Countess Walker.
States follow the religion of the ruler, embodied in the text of the treaty and marked the Peace of Augsburg, 1555. In England, Henry VIII broke with Rome in 1534, being declared the supreme head of the Church of England. The official religion of England continued to be Catholicism without the Pope until after his death in 1547. While in Scotland, the Church of Scotland assisted spiritual independence from the state.
Okay, stop right there. Okay, let's see. All right, now we can go here. Where is it at? All right, Countess Walker.
Okay, the beginnings of modernity in Europe and America. Although the decisive shift from Christendom to modern civilization is rightly located in the French Revolution and the Napoleonic conquest, something important was also contributed by the English colonies in North America and by their successful revolt from Britain. This may be somewhat surprising because in the 18th century, most of the colonists, as Patricia Bonomi has argued, continued to be very religious. The Pilgrims who had settled in Massachusetts were much more devout than the general population in either England or continental Europe. Colonial piety persisted for a very long time and was frequently noted by newcomers from Britain and Europe. We have seen at the end of chapter 34 how much the Great Awakening stirred many of the colonists in 1730 and 1740s. Bonomi prefaced her book with the observation that church steeples dominated the skyline of every colonial city and town, and that for everyone who lived there, the passing of the hours were announced by church bells. She went on to generalize that in 18th century America, in city, village, and countryside, the idiom of religion penetrated all discord, underlie all thought, marked all observances, gave meaning to every public and private crisis. Established churches and religious tolerance in English colonies in America. Devout though it was, colonial America was also a variety of reasons and experiment in religious freedom. The ideal of religious freedom grew slowly before bursting into bloom in 1776. The Pilgrims had left England in order to escape from the coercion to worship God according to the Anglican rules. Other early colonies of Puritan Congregationalists in New England, of Baptists in Rhode Island, of Quakers in Pennsylvania were also peopled by fugitives seeking religious freedom. At the onset, however, most of the colonies were not especially noted for religious tolerance. Of the 13 colonies that eventually became the United States of America, 9 had established churches. In 3 of these colonies, Massachusetts, Connecticut, and New Hampshire, the established churches were Congregational Puritan. In the town meetings held regularly in Massachusetts Bay Colony, only Puritans had a voice. Other religious denominations were illegal in the 3 New England colonies until 1690. When the English Parliament required them to extend to Anglicans and all other Protestants the freedom to worship specified in the Toleration Act of 1689. Long after that liberalization, public tax monies in the 3 New England colonies continued to be channeled to the local congregational parishes. When King Charles I had issued early in 1629 to the Reverend Mr. John White and his associates a royal charter for the English Bay Colony. The king had not established an official church for the colony, apparently supposing that the group requesting the charter was interested in the colony only as a business venture. All along, however, White had intended that the colony would be a home for the Puritans who wished to practice a Christianity purified for all Catholic traces, which Anglicanism under King Charles and Archbishop Lloyd was obviously not. From the outset, New England was also de facto Puritan. In 6 colonies, the 2 Carolinas, Georgia, Maryland, New York, and Virginia, the English kings officially established the Church of England. Public revenues were here used to pay the salaries of Anglican clerics and the expenses of erecting and maintaining church buildings. Unlike the Congregationalists, the Anglicans had to import their clergy from England because no Anglican bishop had been dispatched to North America. Anglican clergy were necessarily educated and ordained in England. In the 17th century, the laws of Maryland, Carolina, and New Jersey provided some protection for all Protestant denominations, including the Quakers. For New Jersey, especially the appointed proprietors offered religious freedom as a means of enticing English families to enlist as settlers. In 2 colonies, Rhode Island and Pennsylvania, religious freedom was an end in itself rather than a practical expedient. From the beginning, the government of Rhode Island kept itself out of religion. It was with this intention that in 1636, Roger Williams, a Baptist, left the Massachusetts Bay Colony and its Puritanism in order to found a new town called Providence. Although Rhode Island was settled by the Baptists, it had no established church. Williams said that forced worship stinks in God's nostrils and insisted that a flourishing civil state may stand and best be maintained with a full liberty in religious concernments. Religious freedom for all monotheists, if not for everyone, was also traditional in Pennsylvania. On December 7th of 1682, the colonial establishment at Chester passed the Great Law of Code Laws that provided for freedom of worship for the settlers in Pennsylvania, many of whom lived along the Delaware River. Specifically, the Assembly put into law that no person who shall confess and acknowledge one Almighty God to be the creator, upholder, and ruler of the world shall in any case be molested or prejudiced for his or her conscientious persuasion or practice.
All right,
Not
stop
surprisingly,
right there. I'm gonna go a little further. All this is enough. Okay. Start. Make sure. From Anglicanism to Episcopalianism. Start there.
okay, from Anglicanism to say that word again?
Episcopalianism.
Okay, home to a few Judeans, tens of thousands of Catholics, and more than 1 million Protestants who in England would have been called dissenters. The American colonies had an ambitious relationship with the Church of England. Although the kings of England and then of Great Britain issued royal charters for the colonies, they did not always establish Anglicanism as the religion of a colony. Largely because it was in the king's interest to encourage dissenters to immigrate to America. In Virginia, the Anglican Church was established at the outset. A law in 1624 stipulated that all white Virginians were to worship in the Anglican Church, but the law was also seldom enforced. All colonists in Virginia, however, were required to pay taxes in support of the Church of England. In Carolina and Maryland, as we have seen, the Church of England was established in 1669 and 1702, respectively. In New York, the Church of England was established in 1693. During the anti-Catholicism loosed in the glorious religion in England. Glorious Revolution in England. Finally, in 1758.
Oh, I'm sorry. What happened? What was that? Okay, go ahead.
Finally, in 1758, Anglicanism was established in Georgia, although in a relatively mild form that permitted public worship of all Christians other than the Catholics. And in none of these colonies did the establishment of Anglicanism mean much more than the continual dispatch of Anglican church clerics from Britain to America and the regular payment of public monies to support the Anglican churches and clergymen. Even in Virginia, only a small minority, probably no more than 10% of the white population, belonged to the Anglican Church by the early 1770s.
Okay.
Oh, slightly more than half of the founding fathers of the United States of America were Anglicans, yet in all the colonies of the Church of England were the one religious denomination that objected to the American Revolution.
So out of all the colonists, foreigners, citizens over here, the only one that objected to the American Revolution was the Church of England. Now we know dealing with the Statutes, dealing with the propagation of the gospel, as well as the Count of Paulette, which were all northern colonies who received land grants for land use, do police powers, and to set up administrative government was actually established by Benjamin Wentworth. Everybody follow?
Follow.
All right, and it was based off, it wasn't secular, but it was based off a theocracy, which was not a state religion. It was based off religious faith, but not a state religion, because it was a state religion, then it went back to that of the crown as established and under the New Jersey Provincial Council, under New Jersey province of New Jersey. Everybody follow?
Follow.
Continue.
As a condition of their ordination, all Anglican clergy had taken oaths of loyalty to King George III, who was both the ruler of Great Britain and the head of the Church of England.
Stop. Now, do we see how many Church of Englands that they just named? They named a whole bunch of churches of England at different times. And all these churches of England were not the right Church of England. Why? Because they were either Catholic or Episcopalian. If they were not Episcopalian, they were Protestants. None of them fit that requirement of the Statutes. Continue.
The Book of Common Prayer included prayers for the king, prayers that he would prevail against all his enemies. Most of the Anglican clergy, especially in the northern colonies, remained ostensibly loyal to Britain in the early years of the Revolution. The laity, in contrast, decisively favored the Patriots. The results was that despite some timid anti-disestablishmentarianism, the Church of England was disestablished in all 6 colonies in which it had been publicly supported. In the aftermath.
Stop right there. There go that word, anti-disestablishmentarianism. And we know what that meant in regards to making sure that the Church of England did not be disestablished by disestablishmentarianism, whereas those who assisted in the establishment of the Church of England versus those who opposed it under anti-disestablishmentarianism of the Church of England. And they're talking about at the time of the Revolutionary War. We're talking about the time of the Revolutionary War, and they actually mentioned the word anti-disestablishmentarianism, and that the Church of England was established in all 6 colonies in which it had been publicly supported. Anti-disestablishmentarianism means support the Church of England. But we read in the town of Paulette that they dissolved it. Everybody making the connection.
Wow.
Yes.
Continue to read.
In the aftermath of the Revolution, American Anglicans disavowed the names Anglicans and the Church of England and became Episcopalians.
Episcopalians.
Okay. Instead, in 1789, delegates from what recently had been the Church of England in the colonies met in Philadelphia and formed the Protestant
Episcopal
Church of the United States of America.
Stop. Back to the Statutes. Let me just pull it up. And then we're gonna close.
That's the distinction between the North and the South.
Oh, I ain't forgot. Oh, I'm saving that for last. And they talking about the Episcopalian Church as well as the Protestant churches who became Episcopalian versus falling under the monarch of the king. That's why the king, the state never transferred from the king, because they all stayed attached to the church under what they call statute of mortmain. Statutes. It says, read this, Countess Walker. Original purpose of the trust.
Oh, both the Statutes are rooted in medieval law, a legal device for avoiding feudal services, most forms of servitude due to an overlord by granting the land for the use of another, one who owed none of this to the Lord. The law of Statutes tended to defer jurisdiction to courts of equity as opposed to the less flexible common law courts. The device was often used by people who might be absent from the kingdom for an extended time, as on a crusade or business venture, who held a tenancy in the land and in return owed feudal services to the landlord. The land could be left for the use of a third party who did not owe those incidences to the Lord.
Okay, so it says that the device was used for those who were on the crusade or left for business ventures. All right, now read the next part.
As such, in trust, legal status was partly to circumvent the statute of mortmain, which sought to end the relatively common practice of leaving real property, land, milling rights, markets, fisheries to the church, meaning of all its branches onto the tenant's death as also so as to avoid dues, inquisitions post-mortem, which could unpaid lead to repossession to the tenancy to the landlord. Two concepts explain the origin of mortmain, dead hand. First, it can be characterized as referring to the deceased donor and former owner and their desire in their will that the church inherit. Second, as the church, a non-natural person recognized by the common law, never dies, and the land never leaves its dead hand.
Stop. Read that paragraph sentence again.
Second, as the church, a non-natural person recognized by the common law, never dies, and the land never leaves its dead hand.
Okay, hold on. This is Supreme Court judge, look at this. Second, as the church, a non-natural person recognized by the common law never dies. So that means that that non-natural person is what? Immortal. Immortal. And the land never leaves its dead hand. Continue to read.
Before this act, vast tracts land were left directly to the church, which never relinquished it. Other land could also be transferred to anyone, inherited only through a family line, sometimes only the male line, or revert to an overlord or the crown upon death of the tenant. Church land has been a source of contention between the crown and the church for centuries.
Okay, between the crown and the church for centuries. Who is the crown? It's the body of politics of the church. The church dropped the body of politics and became based off religious faith, which is secular. Because we know a state church is neither secular or theocracy. We know religious faith just deal with theocracy, belief in a God, whether it's monotheism or whatever other term they got. So with that in mind, and with that in reference to the history and law, knowing that the governor is supreme authoritative figure of the law, shadowing the monarch, and we know that he was the one who appointed the Supreme Court. Now it said that the Supreme Governor is the last court of resort, meaning that you don't need a Supreme Court if you can do everything that the Supreme Court does, right? But being that he had abandoned that incumbency of being the last court of resort, and that's put in place a Supreme Court under the 1947 Constitution, Article 4, Section 7, Paragraph 1, which now they're subject to Rule 133 under the administrative court, under administrative law, Rule 1:33, which deals with administrative responsibility, which means that now you're unconstitutional. As they stated in regards to the administrative judges, which when they deprive you of the three common law rights, which we already read. So in light of that, in closing, look what the Supreme Court has now stated. Queen found this morning, so let's give her honor. And Sister Harris, you can read this in closing. One second.
The Supreme.
One second. Now this is from Politico. This ain't no book. This is not no syllabus from some old theocracy or secular group. This is the Supreme Court talking about the secular groups or the theocracy groups are no longer should be tolerated because they're the reason why we're in this condition now. Read what Judge Alito says. Read it for him, Countess Harris.
The Supreme Court wants to end the separation of church and state.
Read that bottom part too.
Justice Alito doesn't think society is Christian enough. Recent court decisions show how he intends to remedy that.
Now, this is 8/10/2022. So this is this year we're talking about. Read what it says.
Kimberly Well is a visiting professor at the American University Washington College of Law. Many legal scholars in the wake of the U.S. Supreme Court's radical decisions to reverse Roe versus Wade have focused on the dangerous implications of the court's centuries old worldview on protections of things such as same-sex marriages and the contraceptions. This concern is real, but there is another issue with equally grave constitutional consequences. One that pretends the emergence of a foundational alterations of American government itself.
Read that again.
Many legal scholars in the wake of the US Supreme Court's radical decisions to reverse Roe versus Wade have focused on the dangerous implications of the court's centuries-old worldview on protections for things such as same-sex marriages and contraceptions. This concern is real, but there is another issue with equally grave constitutional consequences, one that pretends the emergency of a foundational alterations of American government itself.
One second. Okay.
Considered alongside two First Amendment rulings last term, the Dobbs decision marks a serious step in an emerging legal campaign by religious conservatives on the Supreme Court to undermine the bedrock concept of separation of church and state to promote Christianity as an intrinsic component of democratic government. The energy behind this idea was apparent in Justice Samuel Alito's speech last month for Notre Dame Law School Religious Liberties Initiative in Rome, calling it an honor to have penned the 6-3 majority opinion in Dobbs versus Jackson's Women's Health Organization, and marking international leaders for lambasting the ruling. Alito spent the bulk of his remarks lamenting the turn away from religion in Western society. In his mind, the significant increase in the percentage of the population that rejects religion warrants a full-on fight against secularism, which Alito's likened to staving off totalitarianism itself.
Yeah, go ahead.
Itself, ignoring the vast historical record of human rights abuses in the name of religion, such as the Taliban in Afghanistan, and even his own Catholic Church role in perpetrating slavery in America. Alito identified the communism regime of China and the Soviet Union as an example of what happens when freedom to worship publicly is curtailed. Protections for private worship, he argued, it is not enough, because any judge who wants to shrink religious liberty can just do it by interpreting the law. Alito instead insisted that there must be limits on that power. The limits that Alito is referring to have begun to emerge as the court explicitly seeks to anchor its understanding of constitutional rights in early American history, or even earlier. Under the English monarchy, you know what I'm trying to say, monarchy.
Okay, now stop. It just said that the Supreme Court is referring to have begun to emerge in the court, especially seeks to anchor its understanding. What you mean? You don't have no anchoring in the understanding of English constitutional law because you dropped it. All of a sudden in 2022, this Supreme Court judge, who's a Roman Catholic, I might add, who just mentioned the mistakes that Roman Catholic had a part playing in African-American slavery, he states that the limits that Alito is referring to have begun to emerge as the court especially seek to anchor its understanding of constitutional rights in early American history, or even earlier under the English monarchy. He didn't say the British monarch, he didn't say the Irish monarch, he didn't say the United Kingdom monarch, he said the English monarch. Now that says something, he knows more than he's saying, because he's ending the secular and going back to a church state under the English monarch in so many little words. Go ahead.
Alito and his fellow conservatives eventually panned for a return to a more religious, homogeneous Christian society, but to achieve it, they are deliberately marginalizing one pillar of the First Amendment in favor of another. the dots connecting Alito's personal mission to inculcate religion in American life and what the conservative majority is doing to the Constitution are easy to see. They begin with Dobbs.
Okay, so everybody can look that this case up, this article up. Supreme Court wants to end separation of church and state, and that's not based off secular grounds. It's based off of church state, the origin of where it originated from. So all must return back to the Father, as we have done. And with that, the King's bits digress. Queen.
There you have it, another beautiful lesson from the King. Went over everything from, I had to go back and read the Act of Settlement of 1701. I like the way you broke it down, constitutional law versus administrative law. I also want to familiarize myself with a lot of the different statutes of New Jersey, which I'm not that familiar with all of them, but I have to go back and read. But with the issue of the reverting the decision on the state versus the church, I think it would be a good idea because, like I said, with all the mayhem and all these little wars that's going on in our states today, I think this would be a good implication that would solve a lot of our issues that we're having today, as far as, you know, the disobedience with our children and the disarrays in our households, which would put a light or reflection on the real issues that we're having today. You know, I don't necessarily agree with teaching religion in the schools with our children, because like I said, with a lot of things that our kids are being taught in our schools is not necessarily what we want our children to learn. But at this point, we really don't have any say on what our children are being taught in our schools, because once you put your child in a public school setting, whether it be charter school, public school, whatever you want to call it, you're putting them into somebody else's jurisdiction for them to teach your children what they want your children to know.
Yeah.
And I totally disagree with that. And with that, I digress.
Well said, Queen. Once again, that you have it from our household. We understand the importance of going back to a church state, i.e. state religion, versus that of secular, where anybody can believe what they want to. And if you have too many beliefs, and it ain't the same belief, then there's a problem. You know, so I just thank the ancestors for giving me the ability to articulate this lesson, and I hope it was revealing to you as it was to me. With that, I digress. Archbishop, you can direct the floor.
Well, there you have it, brothers and sisters from the Kingdom of England, Empire of Albion. King Clifford Jefferson had done a marvelous job, as well with Queen Godwin, to put together this lesson to illustrate for those of you who don't see the understanding of religion from a circular standpoint, then from a church state standpoint. As we've seen, even going back to the time of William the Conqueror, he allowed that to happen with his feudal rule, to bring in new different people to be able to, you know, practice their so-called religion. And as you see, based off of the article that the king had presented, you know, we didn't have that ability to be free from our religion, because what our religion is our history and our law. So you can never really be, you know, really be free from that. And if you do free yourself from that, then you're freeing yourself or disconnecting yourself from your heritage, your inheritance. And as you see, ignorance of your law, where you come from, is no excuse. So, you know, we're going to go back to, which they say, a church state, and the church state that we're speaking of was underneath the English monarch, which we have here today, which is our King of Peace. So we don't really care what you decide to believe in, as long as your belief is in factuality and it has to be tied back to our body politic. Otherwise, you're not underneath the same yoke, which is fine. But then again, you need to figure out where you come from. So therefore, you can find the protections that you're supposed to be, you feel that you're endowed with. And like the king said, most of the protections that many people today feel that they're endowed with are so-called religious protections from an abstract belief system that you see that you're actually suffering from today that has not brought you any type of remedy. And even the understanding that you know with those abstract religions are actually based off of the English history. Once you actually start diving into it, in which the king had been presenting to you. So don't expect, you know, the APA agencies to cooperate with you in trying to stand on your religious freedoms, because once again, that's a new deal, and you signed yourself over to that new deal. And within that new deal, you have to find your way to the old deal, because the old deal will bring you back to your body politic underneath the King of England. So with that being said, I digress. I leave the rest of the closing to CA, as well as the rest of the brothers and sisters on the panel. Peace and love.
Well said, Archbishop. CA?
Some heat for you. Can y'all hear me now?
Yes, we can hear you.
Oh man. Ooh, ooh.
I like when you do that.
Woo. The heat, I mean, the heat is, if you can't take the heat, listen.
Out the kitchen.
Peace and love, peace and love, peace and love to all those at the sound of my voice, be it on a panel or the viewer. The king just dropped some heat. Queen just dropped some heat. I hope y'all picked it up. I hope y'all can palate that heat that was just served to you on a platter. I could delineate, but I'm so enthralled with the energy. I'm just saying. Okay, so few points. I'm gonna just touch on them. Anti-disestablishmentarianism. Obviously, the word speaks for itself. You know, those in support of the church. The reestablishment of church into the schools. These little bad, some of us need something. And the whole thing is that we're gonna have our own. We're gonna educate them. It's gonna be up to our pillars and our peers to educate them, because, you know, we've been doing our own self-schooling, but, you know, we have to school them in the right English history. A lot was done to misguide you, misinform you, and miseducate you on your history. A lot was done in the form of religious indoctrination. A lot was done in the form of legal and legislative maneuvering and manipulation. A lot was done to get you to forget. So be it far beyond me not to reemphasize your desire to remember. Every knee shall bow, every tongue shall confess in the abstract, but that's just saying that this English common law was coveted by all nations. Why? Because it seeks to unify and keep the peace among the people so that they can live amongst one another. However, so many people are indoctrinated into a schism that forces them to violence and all sorts of witchcraft and devilish deeds. You know, if anything you're studying coerces you or threatens you or persuades you to be negative in any light, certainly should not be one you desire after. Be that as it may, these rights that you are entitled to as heirs, they precede you. It's up for you to study and show yourself approved. It's up for you to come to church so that you can reattach your mind to the body, reattach your mind to the body that exists now in this day and age, with the reformation of the English Third Temple Church by way of our King Clifford Jefferson, our Queen Godwinson, Archbishop Belmont, myself, and the panel. It is your greatest desire that you reattach your mind to the laws that govern this land, that govern your physical body and your physical plane. Ignorance to the law is no excuse. So therefore, if you're studying anything and you have not studied the laws that govern the way you live and how you live, then you're studying erroneously. Okay? You can't put the cart before the wheel. You can't throw out the baby with the bathwater. So in your delineation, in all you're getting, get overstanding. In all you're getting, you're gathering fiat, you're gathering golds and jewels and trinkets and desiring to learn all kinds of bodies of knowledge that celestial blessings don't build castles. And we know that there are many castles and lands that are here in this Americas that were established by your forebears, your forefathers. So you as an heir, successor, this is your entitlement. This is your inheritance. if you have the skills and the wisdom to claim it by a de jure monarch, through a de jure church, that which is the Reformation Third Temple English Church of England. So again, you are being governed under the New Deal, the APA. You are property cannot, that's where you get the saying property can't own property. Okay, you cannot, with all your purchasing, where is it going? It's going to sit on somebody else's land because you don't own the ground under your feet. So I say all this to say, those may those be encouraged and blessed, all those at the sound of my voice. If those who have ears, let them hear. Seek ye first the kingdom of heaven and its righteousness, then everything else should be added unto you. So we've come to this place by what you see here in this path, we come to this place by our own volition. We come here by our own spirit guiding us to this righteous path. So this is the divine movement. And I say all that to say, because we know that our kith and kin, those who look just like us, some of us are practicing witchcraft and practicing dissuasion and misinformation and other schools of thoughts and doctrines. But that's not what this course is about. Take a clean glass of water and then take a dirty glass, and then you compare. If all you diligent students and studiers, truth seekers, take this clean glass of water to another glass and you compare. And if you come out with it something different, then blessings to you. But this rock shall sustain me. Upon this rock, this truth shall sustain me. So and in my heart and in my household, we gonna serve the living God. We gonna serve the living. You understand? So I might start to ramble. I'm gonna get off, but we already know common recovery. We already know right of conquest. We already know you using eminent domains. Research the words that you choose to use. Those you scholars who think you studied enough, you ain't studied enough. Research the words you use and where the origins of the etymology of where it comes from and your relationship to the status of the word, be that as it may. Our entail estate is de jure. Our entail estate is de jure. And the successors, belligerent trustees, and have been running amok. It stops now. Peace and love to all those who have the sound of my voice. Continue to study. Bring yourself into union with the church. Bring yourself into union with the de jure body politic. Bring yourself into union with the highest equitable interest holder. Bring yourself into union with the entail estate, that which is the most high, manifested into our leader, King Clifford Jefferson, Queen Godwinson, Archbishop, and myself, and the Third Temple English Church, Esquire Burgess, and all of our members of the King's Bench in the prospective houses. I love you all. I trust all is well, and I trust all is even getting better, especially with the renewing of your mind and our hearts. So with that, I digress.
Well said.
Well said, C.A. Murphy.
Before Brother Burgess go, I just want to qualify something. A lot of y'all had a problem with submission. I don't want you to kneel to me. I want you to stand with me. That's what I want you to do. I don't want nobody to submit. I want you to stand with me. And then when I sit and you kneel, we're both showing submission to the seat. So when you watch movies and you see knights and kings walking into the king where he's sitting, that's only showing submission. He's sitting, and for him to stand will be as though the king have to be submitting to that one who's walking in, and it's not. When the king is sitting, then the submission is qualified because it's showing the humbleness for the station where he sits. When the king is standing, he don't want you to come kneel before him. He wants you to stand before him because you're on the same level as him, to protect him. Why would I want to rule you for you to be subject to me? All I want you to do is stand with me. And we all submit before the seat of our governing power. That's the purpose and intent for each and every one of you up here. So with that, I digress. Well said, C.A. Murphy.
Well said, King.
Brother Burgess, Esquire from the House of Burgess.
How y'all doing, family?
Bless.
Well, to go back to a little bit of what I was saying earlier about the those 7 senses, when one is determining that in regards to their standing, whether that's on a collective or individual basis, you're still dealing with self-awareness or your existence or knowledge of thyself, which therefore is a record. And the record of what? The record of life, right? So on top of that, with these municipalities that we're dealing with, when you understanding your history and law from your descending class, we realize that they never fit the criteria, nor they're not using the grant that they had to use schools. They're using it for everything that's causing us to pay taxes to them. So now I'm understanding how vital statistic records came into existence through land use and marking and zoning, and them giving us a legal personhood through all of these descriptions that we continue to choose to use to identify ourselves. It's outside of counter Andrew, fifth counter Andrew. So you came from writ of conquest to writ of discovery to colonization to settlement to taking through regulation to land use, which is eminent domain fee simple, which creates land acquisition. And from that, I digress.
Well said. Well said. Like I
That's
said,
why.
it all means the same. It all means the same, but he took you from the original, fee and simple.
Mm-hmm.
Fee and simple is not a Lodio. Well said. We have Brother Scott from the House of Scott. Greeting, Brother Scott from the House of Scott.
Greetings, King.
Greetings.
Greetings. To kind of
Get your intake
back
on
up,
today's
Brother
lesson.
Burgess, the 7 senses, history, law, faith, theology, philosophy, belief, and hearsay. History and law, will qualify the concrete, and we disqualify the abstract from the 5 remaining senses. You also stated that the Supreme Court has already stated that the administrative courts are unconstitutional. So now I understand this is why they have to use police powers to, proceed and push and take what they want to take through recovery. So I don't really know what to say, King. It's all right there. We're either gonna make claims and reclaim our state, or we're gonna continue to suffer for it. And I really appreciate the lesson. Again, it always brings more clarity. And thank you again. I yield.
It's my job, Noble. Well said. Countess, Brother Gray from the House of Gray. Greetings, Noble.
Brother Scott had to leave early.
Brother Gray?
Yeah, Brother Scott had to leave early. Excuse me, Brother Gray had to leave early.
Okay, well, we know you had a lot to say, but I know I wish you were able to say it, but we're there with you in spirit. Brother Harris from the House of Harris. Greetings, Noble. Only reason why I'm letting the brothers go, because we got a house full of queens and countesses. So we're going to let them take us out. All right. Brother Harris, you there? If not, we're going to move to Brother Means from the House of Means. Greeting, Noble One. Take the nobles out.
Grand Rising, King, Queen, Archbishop, I'd like to say thank you. And also extend out the thank you to you, Archbishop, for sending your condolences if I had mentioned it before the text. I try to concentrate as much as hard. Today's lesson was a very illustrious illustration again to me. Specifically, I think it is imperative to be able to view our visions of being who we are as English men and women with this Administration Act, showing their clear view of them being complete criminalistic organization. I say that because they've taken us out of our place of natural and put us in a place of legal entities. And to be able to operate correctly in private and public, you must be able to administer your private. Therefore, when you operate in public, you still are in your private capacity. To dismember a church unlawfully shows the unnatural fact of who they are and the nature of the beast of what become them going against the charters. And the lesson today proved that once again. Naturala non facit saltam, which means that you see that nature makes no leap and neither does law. So if it's unnatural, it's unlawful. And for those to be ambiguous, you must understand each one clearly in itself. That's all I have to say today. I appreciate it.
Beautifully said.
That brother
Beautifully
means.
said. Our intelligence and comprehension level has surmounted all levels that I could think that will proceed. You know, I just give honor to each and every one of you. And what I'm humble about is that our countesses, you know, we got more countesses up here than we have nobles. It brings me into the movie Wakanda. You know what I'm saying? So hey, and you know the kings surround themselves with countesses. You know, so hey, brother, don't let them take over the spirits. Now I need soldiers, but I take soldier women too as well. So, but I'm just very humbled to be amongst you all, and it's just a great time to hear our women speak, and to see those who view this podcast hear our women speak with such love and such passion. And we're going to start with our eldest Sister Middleton from the House of Middleton's. Greetings.
Greetings, King. Greetings, Queen, and everyone here on the King's Bench. What I appreciate most about King, is that you organize and break down the law from a lot of different levels, a lot of different perspectives, and each perspective reinforces the general lesson that we need to learn. It is important to get in alignment with the true spirit of the law because of so much lack of a better term, insanity and craziness that is just being perpetuated, not only in law, but in our commerce. People are just doing all kinds of illegal things. And it's important to get ourselves in alignment with the true law so that we can begin to change the direction of where this country is going. And I just appreciate all the research that you and the Queen has done, as well as everyone else on the King's Bench. And I digress. Thank you.
Thank you, Elder. And it's our pleasure. And I just love to see what I've given y'all, the use of it. And I just give honor to the countesses, especially Countess Walker. She has great passion and great love for her people. And unfortunately, we can't help everybody, but we can help our own, you know. And when we get to the groundbreaking, we can think about those things, but she hit the ground moving. And I just love her for that. And I just want to honor you to save those that shouldn't even be considered worth saving based off their actions. And you know that the actions are the result of the condition. And that's what you look past. So with that, we give you honor. And with that, we open the floor to you, Countess Walker.
Greetings, Queen, greetings, Archbishop, greetings, everyone on the panel. I do love studying law. If I didn't have to work every day, I think I would stay home and read every day. This was something, you know, I found very interesting because you always hear, where did they get their delegation of authority from? And so this kind of walked us back to where they got their authority from when the royal governors were downgraded to governors. And we went from the first constitution to amended constitutions. And that's when we came out of the de jure law. And then we stepped into administrative de facto acts and procedures. And they don't hide anything either. They never said this administrative procedures was law. So they gave us a set of rules and we agreed to follow those rules. And so when we go into courts, 97% of all the pleadings are plea deals, because you don't know law. So you plead and you step out of law and you step into their fictitious procedures and acts. So and also we left the constitutional realm and we came into the administrative realm. And so this lets us know that we need to study law. And also that was an eye-opener for me as well as the church. We never lost our land, because we could never lose our land, because the church is eternal, whether they recognize it or not. The church is always eternal, and this land that was titled to the church always belongs to the church. And also they never hid that as well, because no one has title. Everyone has deeds, which just shows conveyance and never shows ownership.
That's heavy.
So
wow. That's intelligence, y'all. That's intelligence, she just said. Well said.
Yeah, so they never hid anything. We just never opened the books to research this. So once again, I'm very appreciative of the lesson, and I look to dive deeper into the lesson, because also, as the King illustrated, the state legislature also shows you the acts are in legislation for the state.
You froze up.
Each of our states. So I actually didn't know that the Administrative Procedure Act was legislation in each of the states until today. So thank you once again for the lesson, and I digress.
Well said, Councilor
Walker. Well
it's
said.
beautiful to be able to hear the articulation of the understanding, versus you talking about something that you don't understand, which is beautiful. That's what I look for. So well said. Brother Harris from the House of Harris, did we miss you, brother? Okay. All right, we're gonna move forward. Countess Harris from the House of Harris, how you doing today?
Great. Greetings, King and Queen, Archbishop. What I want to say is, I'm grateful for what you're teaching us, as far as you're guiding us to what to look at, what to pay attention to when to camelback on what Councilor Walker was saying and Milton was saying. You have to know law, but we don't know where to look at with law if you don't know to study law, meaning that we're always been taught to get a lawyer, whereas that's what we've been trained and conditioned to do. But you, King, you're showing us what to look at, what to pay attention to help us in law. Does that make sense? And yes. So today, what I like for the panel, for everyone that's watching this, when you was pointing out as the church being non-natural person, meaning being immortal, and the land never leaves dead hands, and that the crown is the body politic, where right now the churches are not operating as a body politic. They're operating, like you said, as secular. So I like how you sum that up to make sure that everyone that's watching this really understand that. That's very important.
Wow.
Absolutely.
You see that? You see how she took that synopsis and made it would take people years to understand something she said so simple, and we can understand it because we've been talking about it for so long. Versus a newcomer, they'd be like, what the hell did she just say? You can't understand it. Just like the example I gave about Brother Burgess. Brother Burgess can understand because he's been playing the game for a while, just like you now. Y'all been playing the game for a minute now, versus a newcomer. They still got to read these rules. If you don't know the rules, you're not going to understand the game. We know the game because we understand their rules, and their rules are not ours. You play your game, we play our game. Why? Because we know that separates the church and state. We know that. But y'all now realize that your game can't work without these rules in place. So biblically said everybody who spoke thus far. Councilor Alice from the House of Alice. This is parallel to my Archbishop. You know, I just love hearing her speak. She speaks with so much passion, and I just think she's a great example for womanhood, as well as each and every one of you. She's very humble, she's well-spirited, and I think she has a lot to contribute to the standing invitation that other women should look forward to be invited to something. And I just give honor for the spotlight that she gives to all the other women we have here on this panel. Because actually, Sister Allie was with us from the very beginning. So we would just give special honor to her. And she's grasping it real quick. Even though she was the first, she was probably the last to grasp it. But she's grasping it well now. So I just like to give honor to you, and I open the floor to you.
Thank you, King.
You're welcome.
That was wonderful, kind words that you said, and I greatly appreciate it. And I just want to say that what you said earlier, that you don't want us to submit to you, but to submit to the seat of our governing power. That is a profound statement, and it resonates with my ideal, because I come from a mindset of submitting, non-submitting. I was very rebellious in my youth on into my adult years, because I felt that so many things that have happened to me have forced me to behave in a rebellious way. And discipline had been instilled in me over time. The Queen said that this world is we're in a state of disobedience, and I humbly agree with that, because we have gone astray for so long and for so far. We have grasped at everyone's history, everyone's ideology, and we have gotten so far away from our true principles, our true values, and our education of our history, and we as a people. This particular class, I thank you for providing this vehicle, for me, King, because had I not found you, had I not found the Third Temple English Church, I would still be in a world of disarray, trying to figure out where I fit in this world. What is my position? Who am I to follow? And, you have carefully fine-tuned all of these, you put all the puzzle pieces back together eloquently, and it is my honor to serve in this realm, because I truthfully believe that this is the right way. I had a friend who once said her son was 8 years old and he was depressed, and she didn't know why he was depressed, but she realized that her son didn't have anything to believe in. As an 8-year-old adolescent, her family came out of a cult civilization, a cult world, and when she rose and knew from that, she made sure that she didn't teach her children anything about history or their past, because of how she was so connected to that cult world, and the blind faith that was used for intimidation. And her son, as a result, he didn't have anything to believe in. He didn't know where he came from. He didn't know where he was going as an 8-year-old, but he just knew that he was at an understanding that I'm sad because I don't know who I am. I'm sad because I don't know where I'm from. My mother really didn't teach these things to me as I understood it. Furthering with that knowledge, I also led my son down the same path. I didn't teach him about our true history because I didn't know it. I was only teaching him what was being taught to me, and none of this came into play, you know. So I kept him away from the church. I kept him away from the body politic that I have, you know, come to learn and so greatly appreciate. And now, as I look back, you know, I see that all of this disobedience, all of this disarray that we see before us today, it's like everyone is, you know, looking to Kanye West for the next big truth, you know. And I say, you know, you want to come to the Third Temple English Church because this is your anchor. This is our grounding foundation, you know, and this is something that you can't turn away from. It is embedded in our bloodline. It's embedded in our soul. I look at the king and the queen. I really didn't understand all the intricacies that went into a marriage.
Take your time, Queen. Countess, family member, take your time.
And I look at you for guidance. And I look to you as the truth. And I look to you as balance and servitude. It has many meanings, you know, but once you get back to the very fabric of who you are, this is the most explosive thing that I have ever, you know, allowed to enrich my life. And I thank you, and I digress.
Well said. And what the spirit that you said, it brings me in mind with the new movie that's coming out about Wakanda. And there was a statement that T'Challa's main guard stated when they were warned, and her husband, they were fighting, and her husband asked her, she said, would you kill your soulmate? And she said, for Wakanda, without question. Wow. And this is what we need to realize, that we'll stand not for the king or the person who's sitting in that station, but just for the station itself. That was the main key of the movie, about remembrance of who you are. And when the one felt he was cheated from his bloodline, took the sacred herb to go back to the mind of remembrance, because of his remembrance, he didn't want to go back to no more. And he said, burn everything. And he said, no, you can't do that. It's traditional. So what we are doing is traditional. It's traditional, it's customary, it's habituary to maintain our continuous fight to the anti-disestablishment of our English Third Temple Church of England and our English law, in fact. And with that, I digress. All right, Bishop, you got the last word.
Once again, panel, the world, you know, we live in some very trying, serious times. And just based off of, like the king said, with them trying to disestablish, you know, the Kingdom of England via the Church of England, which is the English Church. And without us being tied to our religion, i.e. our true history, as well as law, it's going to make it damn near impossible, excuse my French, for you to be able to pull yourself back up together, to be able to behold your body politic, which goes back to time immemorial. Like they said, it's really going to be many call if you are chosen, because like how the king was speaking about the reference in the movie Black Panther, Killmonger didn't care about his past, his history and things of that nature. And he didn't understand the traditions of Wakanda because he felt that, you know, that he was played, or he was neglected to be that connection based off of his circumstances. And, you know, that's the way a lot of our brothers and sisters today think. You know, they feel that if those of us or those folks who knew who we were, going back to the Kingdom of England, Great Britain, or Albion, why aren't they teaching this history, or why didn't they teach us this history? And so now that the true King of England has returned, you know, it makes it so hard for them, someone who accept it, that they'd rather accept the policies of the APA, the New Deal, because underneath that New Deal, you get what? Child support. With underneath that child support, you have men like myself, other archbishops, as well as esquires and the nobles who have to deal with that. And then you understand that that whole child support, all of that came basically from the history of England. To remind the men to know, like I said, you still have to take care of your heirs, your posterity. So they took elements of what we were to place us in bondage. And now that we see that we had to go and conform back to our body politic and see a lot of the stuff that they placed us in bondage with were just elements of the truth of who we truly are. So therefore we can put ourselves back together and don't run away from what it is that they took from us, but learn from it. So therefore we can do better as we move forward. And as we do so, we no longer have to deal with their New Deal, because their New Deal is no deal at all. It's just you pleading or being pleaded underneath a new jurisdiction, in this case, adjudication. So with that being said, brothers and sisters, this is the only way home. The path is narrow. Like I said, it's not going to be something that's going to be done overnight. And with the showing of the brother Burgess or Esquire Burgess, it shows you that you can get here, you know, if you stick together with your family, you know, you learn from them, you know, and you take your time, because this is not like a marathon that, you know, you think that, dang, I gotta continue to keep doing what I need to do so I can catch up. When you come home, you already home, you know, you already protected. It's just based off you now, you stay on the path. Because once you leave or get excommunicated, that's it, you know, and you no longer can be part of your lineage or your inheritance. And that's what's going to be showing pretty soon here as the world continues to unfold, as the church is going to become a church state again, because that's like how the Queen was referencing how a lot of brothers and sisters, a lot of our children are astray. They went astray. And it's going to really take a lot of work from us to be able to save the ones who can be saved, because everyone is not going to be able to be saved. And that's just the way it is. So like we said, just try to do your due diligence. For those of you who are listening to us, you know, do what you can to reach out to the church, help the church, support us. Even if you don't have the donations, just talk about the church. Like I said, let them know that the King of Peace has returned, because this is what your abstract book has been talking about forever. It told you, stay alive long enough until the King of Peace returned. And the King of Peace have returned. We already verified you through surname, through DNA, through the territory of Jerusalem, which is called New Jerusalem, through the history of the Kingdom of Jerusalem, and showing you that the kings of England were tied to the Kingdom of Jerusalem. So everything you need is right and exact. You don't need the Kanyes and Kyries to continue to keep putting themselves out on the pedestal and taking the lashing from Rome to try to show you who you are. Because if you tie those pieces together from what they're saying, Negroes to Hebrews, you will see those Hebrews were nothing more than those English heirs and successors who came across the river, i.e. who had to become something new based off of the body politic that we were forced into after 1790. And with that being said, I digress.
And to note, for all those who are in that classification, as mentioned by Archbishop, the Kanye West and Irving, Brother Irving, and every one of them, the sister who's locked up in Russia, Brittany Griner. All these are your talents that you worked hard for, that you learned hard, based off your time. That belongs to you. And no one has a right to infringe upon that. But God can protect it. God cannot protect it if you're not dealing with it on God's land. So come back to God's land and all will be well. As I think we just got an email, because why is allodium? It's not based off of land use. It's allodium, and anything allodium belongs to the minority, which they're trying to get back to, i.e. state church. So with that, we love you all. See you soon. And you know what it is. You know what it is. See you soon.
Peace and love.
Peace and love.
Peace, everyone.
Peace and love. All right. Love it.